Let us begin. Today we're going to talk about inchoate crimes, and in this first section we're just going to go over the nature of the crimes and the various tests for attempt, which is one of the principal inchoate crimes that are charged. So the principal substantive crimes that we focus on are anticipatory, preparatory, or unsuccessful criminal attempts. We talk about solicitation, conspiracy, attempt, and even accomplice liability. Now, accomplice liability is a close cousin to these others. Sometimes it's in the inchoate category, sometimes it's in the substantive crime category. Here are some questions that arise with inchoate crimes, and we have to decide when should and can the police intervene in order to stop the ultimate crime from taking place. How do we expose criminally minded individuals to the corrective powers of the law? And can we allow fortuity to exculpate when it would shock our common sense of justice? So we don't want to let somebody off the hook simply because things beyond their control occurred and they weren't able to complete their criminal enterprise. So we have to deal with these three issues and find the right time at which we can intervene as a society. This chart shows you the culpability issues with each of the inchoate crimes. In solicitation, you can see that if you ask another to commit a crime and they don't agree, they're not guilty of anything, but you're still guilty of solicitation. In accomplice liability, you're both guilty of the target crime if you are an accomplice to the principal in that crime. In conspiracy, you're both guilty of conspiracy for agreeing to commit a crime. And finally, there is attempt. And you're guilty of attempt if you take a substantial step toward the commission of the crime, even though the crime may not be accomplished. Now, if we were to have a flow chart of sorts and look at the progression of a crime involving these inchoate crimes, we could start with solicitation. We would then go to conspiracy when the person you've solicited to commit the crime agrees with you to proceed. Then we have the attempt to commit the crime, and that results in the target crime. You should review this slide at your leisure. Now, we do not punish for thoughts alone. You're very familiar with this chart. We've used it several times. Intentional crime is the result of this six-step process. This is Professor Dressler's, one of his great contributions to criminal law. We look for the line between preparation and perpetration all the time, and we know that in America, we do not, in our system of jurisprudence, we do not punish those first three steps because we do not have thought police. However, when the enterprise moves into the preparation stage, that's number 4, then we have some actus reus and we can punish, but most of attempt has to take place in the next step. Most attempt crimes occur when the actor commences the commission of the crime and takes a substantial step towards that commission of the crime. So criminal liability occurs when we hit number 4. Attempt crimes usually are seen when we hit number 5. The big question here in attempt is this: when can and should law enforcement intervene? Early intervention can violate civil rights. It can also deprive actors of the ability to change their mind, the ability to back out. Now, we can't properly police everyone everywhere. So we rely on this ability of people to back out of crimes, to have second thoughts, and we count on that because we can't really just go out there and catch all the bad actors. So we don't want to discourage that either. Late intervention is like rolling the dice. It's very dangerous because if we wait till the very last minute, the crime can actually occur in most cases because it's very difficult to intervene effectively and forcefully enough at that late stage. So we have these 4 tests that you saw on that previous slide, but let's look at them one at a time. The last act test, this favors defendants. The actor must have taken the last step within his power to complete the crime. This provides, however, the maximum ability for people to back out. Locus penitentiae, we call it. This gives the actor the maximum amount of time to reconsider, have second thoughts, and terminate the criminal enterprise. Equivocality is also a test that favors defendants. An unequivocal act is required to show that the actor was implementing a crime. And police will say, and properly I believe, that just about any act is equivocal. It could be something good or it could be something bad. It's very rare when we find an unequivocal act that does not have some alternate explanation. Their example is a classic example they've used for years. Lighting a cigar and throwing the match into a haystack could be innocent, or it could be the crime of arson. So waiting for an unequivocal act is probably hopeless if you're hoping to intervene before the crime takes place. There is a proximity test. Police like this. It provides flexibility for law enforcement. There's no last step or unequivocal act required, but the seriousness of the offense and the closeness in space and time are considered. And that closeness in space and time can be abbreviated by the courts, can be shortened by the courts when a crime is extremely dangerous, extremely serious. The probable desistance test says that a person is guilty of attempt if she has proceeded past the point of no return. Now, this is a dangerous test, as you might imagine. As lawyers, we look for a bright line, and this does not even come close to giving us a bright line, and this takes us dangerously close to completion of the crime and makes it very difficult for society, for law enforcement to intervene. Pennsylvania and the MPC, they cut through all this analysis that we see that is necessary with the common law tests, and they go for the substantial step test exclusively. Has the actor gone far enough to constitute an attempt if the act or omission constitutes a substantial step towards the commission of the crime? There's some flexibility here for law enforcement. It allows the police to intervene early enough to prevent a crime from occurring, but it also gives actors that chance to have second thoughts, to back out. You can see that the MPC and PA look to see how far the defendant's conduct has proceeded from the point of initiation of the plan, from the preparation of the plan to commit the target offense. And the common law test try to see how close the defendant was to completing the crime. So they look at the crime itself and then back into the defendant's behavior. The MPC and Pennsylvania start at the planning stage and move forward, and if a substantial step occurs there, then law enforcement can jump in. There are also dual intents in attempt law. The defendant must first have the intent to commit an act that is necessary for the commission of a crime. This is the intent to attempt the crime. And secondly, the defendant must also have the intent for the actual crime itself to be committed. So these are dual intents, and it's an important important characteristic of attempt law. I want you to look at this note case. This is in our case book, and it deals with Mr. McWhirter, and it details his behavior, his actions on the day in question. There's a question as to whether or not the woman involved here with her child overreacted, and ultimately you have to consider the place and time where this case occurred. The result is egregious. This is a horrible fact situation, I would think, but you need to look at it, and you have to look at it as if you're watching a silent movie. Just observe the actions as described, and try to determine if Mr. McWhorter was up to something, or if perhaps his actions could be interpreted as being completely innocent, completely reasonable. The question is, do the facts here support a reasonable inference that McWhorter intended to commit a crime? If so, what crime? We learn from this final slide that Mr. McWhorter was arrested, prosecuted, and convicted of the inchoate offense of attempt to commit an assault with intent to rape. Now, I find this testimony extremely hard to believe. I'm not sure how they got there, if they were looking at this as a silent movie. But the chief of police testified that Mr. McWhorter confessed that he intended to rape the woman, which is an incredible piece of testimony in and of itself. McWhorter, however, denied that he confessed. And the appellate court said something also more than troubling. The appellate court said that in determining the question of intention here, it was okay for the jury to consider the fact that there was a white woman involved and that the defendant was a Negro man in Alabama at this point in its cultural history. So it's a horrible outcome, but it does show the abuse that can occur if we don't keep a careful eye on the crime of attempt. So we're going to wrap this up, and we're going to move on to the cases, and we'll be looking at the actus reus and mens rea issues with attempt in the next section.